Okay, welcome everyone. We'll start our lesson. Today lesson will go through LO2, learning outcome 2, understand requirement for the creation of valid trust. So how we can create trust and deeds and all, this full lesson will go through. You rate yourself from 1 to 10, current your knowledge about trust and fiduciary power, what is meant by it. So anyone please, can you rate yourself where you up to, what you know about trust and trust law? Yes, Yasir, what do you think, where you up to your current in term of knowledge?
It just I just know that it is between two parties or three parties, something like this, dealing or
Okay, no problem, which will go through. Well done. So you can rate 1 to 10, so where you can
basically related to property and three parties, something like this.
Okay, so you can rate, is it you've been between 5, 6, 7?
Yeah,
Current?
5.
5, okay, in between, okay. Look, so we'll see you at the end of the lesson. Go
Is it
through.
is it something like we use word trustee who look after the property?
Yes,
Related to?
so which will go through, yes,
All
which is
right.
all.
Yeah. Okay, understand now.
Okay, good. So anything you remember from last lesson, what we learned? Yes, Yasir, anything you remember from last lesson, what we learned
Yeah,
last lesson?
we learn about equity and different things. Not in my mind, but yeah, I learn few things.
Yes. So key topic was the equity and types of equity, yes,
Yeah, equity tax.
and
Yeah.
we discussed those, yes. Okay, good, well done. We'll move to the our lesson today. Welcome everyone. We'll start. So key terminology today lesson, what is a trust? So trust is a creation of equity. So we discuss equity is mean your, yes, in capital, your investment, that's the equity. It is easier to describe than they define. So when trust exists, the trustee is the legal owner of the certain property. Especially in charities, we use the trust and trustees. Yeah? In charities,
Yeah.
you have trustees, but is not entitled to use their properties however they wish. Yes, the trustee hold the properties for the benefit of one or more beneficiaries. Yes,
Yeah.
so basically they are holding the property of someone else. Like think about if you are a director in a company or CEO of the company, it's not your company. The company is owned by the shareholders. Yes.
Okay.
So you have some sort of relationship which we'll go through in the further slide. So what are the different types of trust? So fixed trust
Mm-hmm.
and
Discretion.
discretionary trust are two types of trust. So in the fixed trust, the size of the beneficiary's interest is known from the time the trust come into being. Yes. So
Yes.
that's a fixed trust here in the to set up. So discretionary trust is the settler describe a class of potential beneficiaries and give the trustees to the discretion to select which beneficiaries to benefit and by how much. Yes. So you have a
Yeah.
property who will be, yes, more will be, less will be benefit. Okay. Then what are the power in interest? So power other hand is where not only does the hold have a discretion over his action, he has the discretion over whether to act in the first place and ordinary power. So what is the ordinary power then? We heard about before ordinary power. Create no proprietary rights. Yes.
Yes.
So in any beneficiary, nor is holder of the power obliged to exercise it. Holder of power not obliged to actually perform the power. So so-called beneficiary of powers, yes?
Yes.
no equitable right in the asset. They don't have a right in the asset. Yes, within the
Okay.
asset. So give trustee 1K. You may give this to any one of my student. Yes.
Yeah.
In such a case, none of my student get equitable right in that 1K. Yes. Any question? We okay?
Yeah. Yeah.
Okay. Next, two form of powers. First is called fiduciary power and the non. So one, the power being delegated to someone. Yes.
Yeah.
So by law, a trustee or some other person acting in the fiduciary capacity. They don't have their property. They have a property of someone else. Yes. The
Okay.
power being granted to, like a CEO is not owner of the company, but through AGM, annual general meeting, they became, yes, and they have that power, yes.
Yes.
They should be a safeguard of others' bodies' assets, yes, because that's not yours. So fiduciary powers are the power in a different sense. They are not part of the trust, but a pure power, something that can be done, but does not need to be done, something valid but unenforceable.
Okay.
So the person who may benefit from the power cannot make the fiduciary exercise the power, but can make sure this consider exercising the power, and Donny of the power must not act unreasonably in making the decision to exercise the power. Yes, they
Okay.
should make the reasonable decision. Yes,
Yeah.
so the power that is held by the person who is in free position, such as trustee, it is the status of Donny of the power that make its fiduciary powers. Yes, that's been given, that's been delegated. Any question?
No. No.
Okay, then non-fiduciary powers are personal, we can say given to any person in their capacity. Yes, when they
Yeah.
are not acting as a on the behalf of someone. Yes, that is
Okay.
tension between these powers. Fiduciary is the requirement to act utmost for good faith of others, like which we said, trustees, yes, and trust, and we quoted the CEO examples. Is the prevented from the acting or irrationally and cannot act on their whim, need to be justified their exercise of their powers in the manner that it has been exercised from the time to time and need to be considered using their powers. Any question?
No. No.
Okay, now we discuss about trust, types of trust here, types of power, and now we're looking the analyze the feature of different types of trust. One is a discretionary trust. Between the ordinary trust is imposed obligations on the trustees, mere powers granting on the ability to advance the properties. There are powers in form of trust which impose the obligation on trustees, but nevertheless give the trustees some discretion. Yes, they have a discretion to whom they want to be allocated the properties. Yeah, those sort of things. So as to the manner in their duties are to be performed. So next we're looking the fixed trust. What is meant by fixed trust? Refer to those situations in which the trust provisions require that the property to be held for the fixed number of identified beneficiaries. Yes,
Yeah.
like those member can get the benefit out of it, no outsider. And
Yeah.
clearly the name. Settlers tell the trustees already, and their respective shares is fixed, but doesn't have to be equal. Like 10K to be held upon the trust equally for my two sisters. Yes. The
Yeah.
trustee should be able to create a list of the beneficiaries, and because of if he can't tell us whose exactly the beneficiaries are, he might end overpaying them, yes.
Okay.
Can be, but he doesn't know, he thinks there are only 8, yes. He will end up overpaying them, which is a breach of the trust.
Okay.
There are the rules. We need to be look around what is the written, yes. We impose the trust, beneficiaries. If we don't know exactly, then we don't know who has the power to petition to court for the trust. Become the resulting the trust, know the trustee holding the benefit for the settler, and if I am dead, to my estates, yes,
Okay.
properties too. Okay. So for example, T shall distribute all 1K equally to any my grandchildren who have enrolled for a full-time university degree express trust. So we learn about in employment laws, in contract laws, yeah,
Yeah. Yeah. Yeah.
express terms,
Ji, ji.
implied those we can. So T has no discretion about the amount of the property to be held for each beneficiary. Yes, rather the trustee are obliged to act in the limited manner. The beneficiary of the property's right is equitable interest, trust fund according to the term of the trust instrument. So differentiate the trust from the power. So it is important until the power is exercised, the beneficiary don't get any proprietary right. The fixed trust for whose benefit and how much. But he can't make the list now because he wouldn't know which of my children will be enrolled for the degree. Yes?
Okay.
So that is not a fatal to the trust. He doesn't have to be write the list now, but when the trust is performed, yes, when somebody join the degree, yes.
Yeah.
So like you're giving the conditional. So complete the risk. So we have some the case laws versus here, yes.
Yeah.
IRC versus Broadway Cottage. So if there is any claimant about whom the trustee's beneficiary could not be certain, the trust will void for the uncertainty. Yes.
Okay.
So what is identify the membership of the class cannot be known until the identify the time in future at which trust is to be performed. Yes. Like this is Pond versus Law Society, the case, right under the standards versus this is by the product. This is the type of the trust. So we need to be make sure we have a clearly understanding and clearly guidance, different types of trust. Yeah. So when we deal with the trust laws. So £1 to X when my daughter graduate from the school, last school, and one created the trust. My daughter can go to the trust and say she's an adult and have 100% equity title. So daughter can go to the court, yes, and get the money. Doesn't matter if settler say she will only get the money once she graduates, yes.
Okay.
So see the condition was there. Okay,
Okay.
so what we can conclude there, so discretion trust, it is the important to be certainty of the object so the trustee knows who to be considered when deciding how to distribute the trust property. Originally, the test, for the discretion trust was the same as the fixed trustee. Yes, complete the list of the trust, and however, this caused, the many problems for the discretion trust as they are usually more potential beneficiaries for the discretion trust. Any question, Yasir, here?
No, no, no. That's fine.
Okay, so this means the potential beneficiaries will have to show the fix, the within the fix, this, the within, so we need to be make sure, yes, fit within the
Yeah.
discretion of the object. So this is the easier then the complete the test, yes, because the one person cannot be proved they are the potentially beneficiary, the trust does not fall for the uncertainty. So just the individual who did not satisfy the requisite, yes, so we need to be criteria is not entitled to be considered to be trust property. Yes, so we need to be draw the criteria there. Any question there, Yasir?
No.
So we need to be make sure the fixed trust is subject to the condition. Yes. So that's we need to be fulfill the condition. If no certainty object can be ascertained, the trustee will hold the property on the trust for the settler. Okay. Next we look in 2.2. What is the 2.2? Apply the statutory rules, their cases. Yes. Interpretation into appropriate scenario. So what do you mean by statutory rules? Yes. What is meant by this? Is the rule, yes, regulations, yes, by law under the any act of parliament. So act of parliament we call other, yes, statutory rules, yes. In the English law, there are the three types of the rules exist in the courts. Do you remember we learned all these, in other unit as well, yes? These are the rule most commonly approached in the examine the maintaining the language used into, which will go through like golden rules and yes. So those sort of, which we will go through in a minute. So we need to, without these rules, the readers would not be able to interpret the meaning. So that's why we have a rule there. Otherwise, the interpretation in different laws can be difficult. So reader who apply, which is known as statutory interpretation, the rule for the examining the wording of the particular statute, particular law, most common approach to interpretation is known as literal rule. Yes?
Yes.
So we learn about literal rule, we learn about golden rule, yes? And we learn about mischief, yes, rules.
Yeah.
Do you remember, Yasser?
Yeah.
So literal rule takes precedence, yes, over the other states, yes, and the word in the statute must be interpreted to the meaning exactly that they say, however absurd or unfair the conclusion. The rule is based on the doctrine of the parliamentarian supremacy, yes, and judges are not allowed to make the law. They have to, yes, whatever said to in law, whatever been act of parliament was, yes. To avoid the allegation of the laws making, judge often stick to these rules and take a literal meaning of the statute. Yes. The reason to use these rules created the loopholes. Yes. Loopholes. Yes. We need to look around has the potential to be defeat the parliamentary intention when writing this statute. So cases are and the precedents have been set will then require the parliament time to correct it. Any question?
No.
Okay, there are the good few case laws is R versus Harris, yes. Statute made the offense, yes. Cut or the wound another person, yes. The bit of the friend nose in the fight and then the policeman fingers. This was not found guilty on the basis of the word. The statute pointed toward the use of weapon and the teeth are not considered as a weapon. Literal rule is often criticized when the outcomes are weak. R versus Harris here does appear to be the rule against the using reader's intelligence. Yes, common sense is more. Yes, we need to look around. The rule does not exist, then the court would have to be power to interpret this. So literally, yes, is a claim, but if not, then judge can interpret it in different scenario and different. So literal rules also involve two subsidiary rules. Yes. So first, no stress, or we can say Sochis Rule. Yes, which means word must be determined by the context. So the rule is, when you said it, yes, what was the condition? Why you said it, yes? Is it by force somebody said you to say something or not, yes? It just enrich, which means that any general term depend on the specific terms, yes? Are beside it. For example, laws refer to the automobiles, truck, tractors, and motorcycle, then the term vehicle would not be include aeroplane, yes? And since the list of the land based is on the transportation. Any question?
No.
So now we discuss about the literal rule. Now is the golden rule. Rule that describe the shadow of the literal rules, yes?
Yeah.
And should be used as a backup. If the literal rule produce, so tell the readers of the student to read the word in the context of the sentence, yes?
Yeah.
Look the contents, that's also the rule. But if the literal not clear, you can use the golden rule then, yes? If
Yeah.
there is ambiguity, so you can follow the golden rules, yes? Second, it can be used to modify the word. It has only one meaning in order to avoid the absurd outcomes. Yes, different outcomes can be different meaning. Then we have a next rule is a mischief rules. Is
Yeah.
attempt to determine the legislator intentions. Yes, why they said it at that time. What was, because if something is being said in past, yeah, it's not mean will be happen now. Yeah, so pass remedies to the common loopholes. Yes, mischief.
Yeah.
The court used the rule to decide whether the loophole, yes, the suit was intended to correct or close. In doing, the court go beyond the word of suit, ascertain what loopholes, yes, states
Yeah.
suit the remedies we can in that case. This is one of the case law in 1958. Any question here?
No.
So we learn about common laws also can case laws, yes?
Yeah.
And we have here Cockery versus Carpenter in 1951. Yes, a person was in charge a bicycle while drunk, and it is offense to be drunk in charge of carriage. Yes, the
Yeah.
court held that the bicycle is a carriage. Yes,
Yeah.
and Mischief was the drunk on the highway being in charge of the transport, and it would have produced an absurd result in the literal interpretation of the statute had been used. So in this case, any question?
No.
Okay. Several types of trust which we discuss. The fixed trust. What are the trust was?
Yeah. Trust is like a two types of trust, and trust is as you
Yes,
said that.
there is a no fixed, you being delegated the power of
Yeah.
fiduciary relation,
Yeah.
or we can say
It
power.
can be, it can be anything. Trust can be anything.
Yes.
Okay. Yeah.
So certainty of intention. So the key test establish whether the requisite intention is present to consider. So certainty of intention, yes.
Yeah.
We need to be look around, yes. We need to be make sure, yes. And whether they create the trust unwanted someone to under the duty of hold the properties at the benefit another person. The use the trust need not to be present to show the certainty intention. However, when it's used, may not show the certainty intention depending on the context. Yes, what context the word was used. Yes, the
Yeah.
court will look the substance of the creator and intend to see why that was, why the property being given to. Yes,
Yeah.
is it for the sake of the saving the tax or any other purpose was? Yes, what was the intention? Is really being given to somebody here? So we need to look around the intentions. Huh?
Yeah.
Okay, then we have this next case law. It's quite good to be.
And then, why they use this word specifically for what I say that charities or charities and NGOs trustee?
Because they registered, with the is called, charity trust. They registered in the is a charity commission, yes, which is a trust, and the
Yeah.
trust lies the 2012, sorry, 2011, yes.
Yeah.
So if you registered under the Charity Act 2011, yes, so we can use the word trust and trustees, yes, and then in the condition it can be fixed or not fixed, trust, huh?
Okay.
Or the condition of the trust, or the relationship to being delegated to trustees, yes.
Okay.
So this is about the N in RE Gulbanikan, yes, 1970 AC, yes. The was is one of the case law states the ambiguity in the court must use innate the common sense, yes. If
Yeah.
there are the you use the common sense. That's why the judge to make the professional judgment, yes, based on the facts and figure, based on the law, based on the situation. Yes, that's quite is the crucial to be make the yes language that may have been used. The reasonable meaning of that language can be different meaning, different interpretation to different people, different even in the culturally sentiments. Yes.
Okay.
So spontaneity, intention, the problem situations where the self declaration to trust. Yes. A father received a check of 900 and said he would put in away his son. And this was held not to show sufficient intent to create an express trust. Yeah? Then the Lord noted that it would be dangerous if they lose the conversation of the sort declared, yes, a trust in relation to the commercial matters. Yes, there is a reluctance of the court to find the trust arising from the commercial relationship. However, the necessary intention is present and trust will be found. Yes, that's
Okay.
basically we need to think about here lot of rule about trust itself, but unfortunate, yes, sometimes the trust not been, but in the law is a law, yes. If there is absence of the certainty intent to create a trust, there will be no valid declaration of the trust, yes. If the creator of first trust transfer property to someone else and trustee and they may take the properties, yes, for the benefit, yes. Any
Okay.
question here?
No. No.
For their own interest. Certainty of the subject matters. So we need a trust can be declared over all kind of the properties, including the intangible. Do we know intangible, tangible?
Yes. Tangible, intangible. Same
Equity,
as
goodwill,
yes. Use
copyrights,
to
and those.
intangible like a goodwill. Yeah.
Yes, so we need to be make sure we need to be good well aware of
Yeah.
certainty subject matter. So trust can be declared over the kind of property, including intangible such as convenient or the debts. Yes, however, the subject matters must be clear define the trust instrument. The question of the fact is the creator or the describer the properties as the bulk something. Yes, Plummer versus Simmons. Yes, this is in 2 to 1 said was not sufficient constitute in the certain matter. Yes,
Okay.
there was a law. So what we need to we have a trust state. Yes.
Yeah.
So because the bulk cannot be defined, however, according to the decision, anything left to the tester, the state was held sufficient clearly. Yes, clear.
Okay.
So these are good, the few case laws we can read, and that will help us, to furtherly. So please, Raman already uploaded some case laws for you as well. So please,
Okay.
go through. I'll refer you those as well, and it's good to be enhance your understanding about the trust. Yes, tangible,
Okay.
intangible. We already discussed. Tangible is we can see as a physical substance. Intangible we count that's a goodwill. Yes,
Yeah.
stays in the properties are the so this is one of the case law again, yes. Of the
Yeah.
London versus Mine, yes, shipper. So trust and trustee, yes, you're giving the property, someone else you can. So if there is any absence of the certainty subject matter, the consequences will be depend the kind of uncertainty, yes. If identify the trust property is not certain, the trust cannot be attached to any property, yes.
Mm-hmm.
Okay, therefore the part of the property to be held on the trust for the beneficiary and identify uncertain and trustee will be obtained the property? Absolutely yes. However, if fail to uncertainties in the way the property is divided up between the beneficiary, the resulting the trust will occur. The evidence the creator of the trust did not want to give the properties to the trustees. Yes, outright.
Mm-hmm.
If they mean, yes, they should. Certainty object, yes. You
Yes.
need to look around. What is, yes, the object of the trust will depend upon the types of the express. So, like we discuss about the terms, yes. That's we need to be really. Okay, next 2.3. We have 2.3 is all about illegalities, yes.
Okay.
So, and the presumptions, yes. So, what is the illegality? Contract is illegal when formed. Neither party will acquire the right under the contract, yes.
Yes.
Regardless whether these are any intention to break the law, the contract will be void, yes. It will be automatically finished, yes. Like contract about to kidnap somebody, yes. That itself be against the law, yes.
Yeah.
That will be void itself, treated as if never be entered into. Illegality in the contract law, yes.
Yeah.
Broad system, the court will not enforce the contract, yes.
Mm-hmm.
Express or implicit are forbidden by the statute, yes, by the law itself. Illegal, yes. Illegal goods, illegal, yes. Drug, are you saying drug transfer for suppose, for the sake of example, huh? So this is not a contract. Yes, you say sorry, you're not doing it now, and somebody say no, you are agree to do things. Yes,
Mm-hmm.
it wasn't contract even in the law. Contract includes the sales of the distribution of the controlled substance. Yes, such as drugs, like I mentioned. Yes, agreement make illegal activity that can't be what we said. Contract consideration. Yes,
Yes.
in contract laws. Yes, we learn about the 5 steps in the contract laws.
Mm-hmm.
Prohibit express. Those are the provisions. Yes, so we need to be prohibitions. Express is the type of the contract. In the term, there is no question to be illegality. Neither the party will be able to force the contract, irrespective yes, sense, and either the both parties. So this is one is R versus. So that is good to be read, please. We have some case laws there as well. Yes, Bean, I'll show you. Any question on this one?
No. No.
Express and implied, these terms we learn in the contract law, even in employment law as well. Huh?
Mm-hmm.
Written or whatever, you do yourself. Huh? But that also become the part of the contract, yes? Is enforced by the law, and enforced by the written to the contract. Okay. Then the common laws. We know the common laws, yes, is a case laws itself.
Case laws. Case laws.
Ground on the public policies on the moralities, yes, welfare of society. Anything can be void if the voided interest of the public will come off. Yes, there
Yeah.
can be. So the court approach to the area of the law, which is consideration of the common value of the society. Contract is a breach, common value of the society is a void. Can't be, yes.
Yeah.
Illegality. Lot of examples can be, yes. Contract to the commit crimes, yes.
Yeah.
There can't be contract, yes.
Yeah.
Contract which prevent the administrative of justice. Despite the law of the contract, most self-regulatory in the event of the dispute, the court will intervene in the contract which is precluded parties of the contract, assessing the justice and prevent the court interfering with the contract. May be illegal on the ground that the prevent administration of justice. Like in this case, yes?
Okay.
Amen versus in 1929. So it's good to be, because as long we not read the full case, it's very difficult to interpret itself. Yes, so that's why it's good to be need to be look around. So contract with this is immoral, yes, sexually activity. So we need to be look around the refer to the relating to the contract. Yes, act
Yeah.
service. So however, this is approach was evolved along with the society's views as well. Yes, like nowadays, for suppose lot of this news maybe LGBT and various others.
Yeah.
So we need to look around. Okay, common law is prohibition of the contract, restraint. So there is ensure that there is a continuous freedom of the contract by force it. Yeah? Void if somebody on the gunpoint or something, just force it. Or sometimes people use the power to enforce to other. You will be enter into the contract. That contract can be void as well. Yeah?
Yeah.
Any question on this?
No.
Okay. Then we have is the contract is reasonable? So we need to look around the good, the journal pre-exemptions deciding whether or not the contract may be illegal due to disproportionate or restraint on trade. Yeah. Employment contract restricted farmer employees from being employed by the competitors. Yes.
Yeah.
Can't be. Yes.
Yeah.
Employment contract that prevent the loss of the trade secrets. Yes. Stealing of the custom would normally be valid. Yes. The term in the contract sales of the business prevent the seller setting up another business, yes, in the
Yeah.
competition with the purchase of the business. Okay, then the effect of illegality, the case Holman and versus Johnson in 1775, yes, is authority, it's quite old case, yes. General principle of illegality, the illegal contract will be unenforceable. Yes, which we learn about the contract law, which is unenforceable, yes, can't be enforced. Several illegal contract, the court the power to enforce the contract, but only when the illegal part of the contract have been removed. Yes.
Yeah.
So in the contract, maybe there are some elements can be illegal. Yes.
Yeah.
Blue pencil text can be illegal provision of the remove without modifying the words remaining terms. Yes.
Yeah.
Makes sense. Illegal provision can be removed. Yes. Okay. So collateral contract where the one illegal contract, but there are the collateral contract that allow to recovery all the part of the contract. This may be enforceable, but only providing the remedies of the collateral contract is not equable and enforce illegal contract. Yes. So maybe two contracts attached together. Huh?
Yeah.
Any question?
No.
Claims based on the illegal contract, of course, can't be recover under the illegal contract. Yes,
Yeah.
recovery. Final assessment to make when the considering illegal contract, whether or not the money or the property may be recovered subject to the contract. Yes. Both party are guilty. Yes.
Yeah.
Both party are guilty in the relation to the illegal contract. Yes.
Yeah.
Like in Holman and Johnson in back. Yes. So we need to think about human rights. Yes. And various areas. So this is one of the case law as well, which is dismissed by the court in 20. Okay. So one part is unfair, induced into the illegal contract. Yes. Guilty of entering illegal contract, but one party has been forced into the contract as a result of duress or undue influence. Yes.
Yeah.
If you don't do it, we will tell to authorities, you will be, yes.
Yeah.
But the victim of the success of the recovery money or the properties is past subjective. So this is one of the case law versus, yes, Liverpool versus Victoria legal. So please, so these are, the case laws which we cover in 2.1, 2.2, 2.3. We have other criteria as well to look around the merit and distinction criteria. So please, you can go through equity and please make sure, go through the equity and the trust, yes.
Yeah.
And this is good to be read. And for 2.3, finding the principal illegality and the reflection on. So please, Tingley and versus Milligan. So go through this, and we have one other 2.3 as well. Yes.
Yes.
So the effect of illegality since the Patel versus Mirza. So it's quite good to be read, please. Yes.
Yes.
So if you make sure you read before our next lesson, so we can do a bit discussion on these case laws, and we can move to yes. And we
You
our
yeah.
distinction criteria.
I can get these on Moodle. I mean, you will send it now.
These will be available on Moodle, and in the meanwhile, if you have any question, you can drop me email. I can send you as well.
Okay.
Okay, so we'll keep up to here. Anybody any question before finish? Okay, guys, thanks for listening and attending. Today lesson we discuss about types of trust. We discuss about power. We discuss about the in the contract, different. We'll discuss about literal, golden rule, yes, mischief, and we discuss about type of contract. One contract can be void, and illegality, yes, if any illegal section of the contract can be void, and that's all we discuss. In the next lesson, we'll go through LO3. If you have any question in the meanwhile, please feel free to drop me email and copy into learnerwork@ukversity.co.uk as well. And hope so speak you all during our next lesson. Thanks for listening and thanks for the time. Bye bye.